I want to welcome and thank you all so much for joining today's panel discussion on prosecution and sex trafficking, the criminalization of survivorship. My name is Michelle Mason, and I'm a Policy and Operations Associate at the Institute for Innovation and Prosecution. Today's panel is the third in a series of 4 virtual panels on human trafficking intersectionality in the criminal justice system. I'd like to thank John Jay Student Council for partnering with us on this series, and I'd like to thank the John Jay Pre-Law Institute, the Office of External Affairs, and the Psychology Department for co-sponsoring this series. Please follow our socials at IIP_JJAY to register and stay up to date on all of our upcoming panel events. I'd also like to take this time to read our land acknowledgement statement, which honors both the land and culture of Indigenous peoples. We want to acknowledge that the IIP and John Jay College are based in New York City, which is Lenape-Hoking, the Lenape homeland. We honor all of the Indigenous nations and their land with great gratitude and acknowledge the genocide and continuous displacement of Indigenous peoples. We also acknowledge the enslaved Africans whose labor built Manhattan during the colonial era and beyond. We acknowledge the harm inflicted upon Indigenous communities and people of color across the country, which inspires our ongoing work. Now, today's panel discussion is going to cover a wide range of topics related to the criminalization of survivors of human trafficking and other forms of gender-based violence. We have a group of amazing panelists who have worked closely on this issue from different angles from within the system. We have a lot to discuss, from the effects of trauma, the role of the prosecutor in trafficking cases, and some current legislation that is helping to address criminalization. The content in today's discussion may be particularly sensitive, and we encourage you to step away from your device and do what is best for your mental health and safety throughout this discussion. It is now my privilege to introduce our panels for this evening's discussion. And for time's sake, I'm going to keep the bios very short, and I'm going to put a link of the panelists' full bios in the chat. I encourage you to check them all out. We are so lucky to have this group of experts who are being so generous with their time. So without further ado, please join me in welcoming our first panelist, Ross Kramer. Ross is the director of the Incarcerated Survivors of Gender Violence Initiative at Sanctuary for Families. Our second panelist is Kim Brown. Kim is an activist and advocate for gender-based violence and formerly incarcerated survivor. Dr. Chitra Raghavan is a professor of psychology and the deputy director of the Forensic Mental Health Counseling Program here at John Jay College. And Ryan Wall. Ryan is the staff attorney for the Exploitation Intervention Project at the Legal Aid Society. And last but certainly not least, David Weiss, who is on our panel series for a second time. Thank you so much for joining us again. And David is the deputy chief of the Human Trafficking Unit at the Kings County District Attorney's Office. Thank you all for joining the panel. And before we begin, please use the Q&A function at the bottom of your screen, and you can send questions throughout this evening's panel. And if time permits, we hope to respond to some of your questions. So we're going to jump right into this discussion. And to begin this panel, I think it's important for us all to get a basic understanding of the psychology of abuse and coercion. So my first question is for Dr. Raghavan. Your research has been essential in providing lawyers with an understanding of how and why trafficking survivors are coerced into committing crimes. Can you briefly share your work on the psychological effects of abusive relationships, specifically between survivors and their traffickers?
Absolutely. Good evening, everybody. I usually take a semester to explain this, so let me try this in a minute. Essentially, the forms of abuse that happen are very particular to the victim, in which they trap her and they make her feel that she's to blame for the abuse and that she is responsible for it. At the same time, she's also manipulated and frequently isolated emotionally from support. And these sets of things lead to her often, not always, but often forming what we call a traumatic bond, a trauma-coerced attachment with the abuser. The way we should really think about trauma-coerced attachment is that it is a form of trauma. It is, in fact, in the DSM-5 under other dissociative disorder. And just as if you were in a car accident and you can get post-traumatic stress disorder, if you're in a relationship with a particular kind of abuse, you can develop a trauma-coerced attachment. The characteristics of this very quickly are a belief that there can be no one greater, that you're lucky to get this person's love, and if he punishes you, it's because you did something. These are all symptoms of a particular traumatic outcome, and I'll stop there.
Thank you, Dr. Agvan. And my next question is for Kim. And prior to your incarceration, you had actually reached out to law enforcement when you were experiencing domestic violence. I was wondering, what were some of the inadequacies of the criminal justice system when you first reached out for help that you think might have led to your ultimate re-victimization than by the system?
Well, thank you for having me. I think, I had my boyfriend arrested 5 times. I had a file at the local battered women's shelter. I had hospital records, like I said, police reports. But every time, one time in particular, I had him arrested after an excessive abusive incident that actually lasted like 16 hours. I had him arrested and went home and thought I was safe and went to sleep and woke up and he was standing over me. So I think the lack of the police taking things seriously and the lack of my credibility. I was the hysterical battered woman, and they didn't deem me credible. But I didn't know how else to be. You just are the way you are after a particular incident. So I think that taking domestic violence more seriously, because back then, I mean, I have to say I'm very disappointed that the system hasn't really changed that much in almost 30 years. I mean, Tanisha Davis's case mirrors mine, and this is a recent case. So I think the DVSJA is a start, and I think that's the direction we're trying to push in.
Thank you. And we're going to touch on exactly what the DBSJA is later on in this panel to explain it for some people who might not know. And my next question is actually for both Ross and Ryan, because I think a really important part of this, and possibly outside of just law and police officers who are the first interaction that a survivor may have, but this is your first chance to really help a survivor and understand and get the full story. So I was wondering if how you as an attorney have assisted survivors who are coming to terms with their victimization and how they've worked towards healing their trauma.
Well, I mean, I'll add some practical considerations. This is a difficult exercise in the best of times. You're talking to someone who you're asking them about the most traumatic thing that's happened to their lives. You're talking to them at a time when their life has been totally upheaved. Many of them have been arrested and find themselves in prison. They don't understand always even why they're there, why they're being treated as a defendant rather than a victim, as a survivor. And you're trying to get a story out of someone that's very difficult for them to tell. And right now, as we all know, it's infinitely more difficult because I'm taking on cases where I can't even meet face to face with the person that I'm going to be representing, and I'm asking them to share the most intimate details of their relationships and the tragic circumstances of their lives. So really, what it is it's an exercise always, but even more now in building a relationship of trust and comfort. I think that one way that I've been able to do it is I often try to talk about as many other things about their lives as possible. I think that when you're representing someone in a situation like this, you have to understand them holistically. So we'll spend a lot of time talking about how they grew up and their family circumstances and other things in their lives and their children, things they're happy and excited still to talk about. And then, I found it powerful to be able to explain to them why I'm going to be asking difficult questions. I'm not asking for it just to, create a narrative for myself, but especially now with the DVSJA, there's real tangible potential for someone who is, going to be sentenced or has been sentenced and could be resentenced to get their story out and to have an advocate, either for the first time or the first time in a decade or 2 decades for people who are incarcerated. And I found that really helps people, open up and really understand why you're there. And I just had one, kind of practical thing that I've run into. I'm a career criminal defense attorney, and I know that a lot of the people watching are trial lawyers, either defense attorneys or prosecutors. And trying to get a story out of someone in a situation like this who's experienced severe, prolonged domestic violence is so difficult and so different. It's always difficult to have a client who changes the story over time or only comes to grips with things and able to talk about it over time. But you really have to be understanding, the complex PTSD that they have suffered for, over a long period of time. Sometimes they don't tell their story in a narrative way. It's impossible for them. Sometimes they tell the story differently at different times. And you really have to be understanding and understand the background to why they're unable to do that and to help them build that up. But it's very, very difficult.
Yeah, I think Ross touched on a lot of really important aspects of, the challenges that an attorney faces when they're representing a victim survivor. I can just add on to that. I think there are strategies for talking to survivors of trauma that help facilitate a conversation that is less like re-traumatizing. A trauma-informed model is something that can guide a practitioner in their conversations with survivors and make sure that it's a thoughtful process, that an attorney is not just coming in and casually bringing up maybe one of the worst experiences in somebody's life. That should be something that a practitioner thinks about in advance and makes a plan. And I would also add on working collaboratively with service providers. There are exceptional service providers that are specialists in working with survivors of domestic violence, gender-based violence, trafficking, and having one of those people or a cohort of those people work with you is going to create a much more successful experience for everybody, but most importantly, the victim survivor.
Can I jump in super quickly? One of the things, I've been doing this work for 20 years, but I still struggle with the level of detail needed for the case to be strong or the level of detail that's extraneous. And so I think it's a balance because you have to get details if you want your case to be strong, but at what point are those details unnecessary? So I work a little bit with lawyers when I do this. They don't tell me what to do, but I ask, which incidents are more important? For example, if we know there's 8 incidents, or is there or is that a decision I need to make? Because if there's 8 incidents, asking her about all 8 is painful, time consuming, and confusing for her. And so it's really, I want to say this as a form of encouragement. If folks do this sort of work and they're struggling, it's because it's difficult. And I still struggle. It's a good struggle, but I still struggle.
And Michelle, there's the one thing I would add is in another form of encouragement. As much as any clients that I've ever represented and worked with, you can really see changes in people, in survivors, just by being out there as an advocate. And there's so much value to it, I think, especially people I work with who have been incarcerated for a long time, lost touch with their previous attorneys, and maybe didn't realize, that there was potential for a future. But getting to talk about these things, with clients and seeing how they are able to, in many cases, especially younger clients, kind of come to grips with things and come out of their, start to come out of the trauma that they experienced. This has been a very fulfilling practice as an attorney, trying to, work with very vulnerable clients like this.
Thank you. And I want to follow up with your point, your first point, Ross, and as well as what you just touched on, Dr. Raghavan, about the importance of having this linear story. And I wanted to ask you, Dr. Raghavan, if you could briefly explain also why it is so difficult for survivors of trauma in general, why it is so difficult for them to piece together this linear story or even have a consistent story throughout the course of a case. I think that's something that prosecutors, judges, and juries really struggle to understand.
So 2-part answer. Part 1, our consciousness is not linear. By that, I mean, we actually don't think linearly and our memories are not linear. This is true for everybody. What we do is we actually plug in things to make our stories flow comfortably for us and people around us. But how is it that we don't notice it? Because the things that we're plugging in have very low stakes. They might be what I did for dinner or what I didn't, or how many glasses of wine I drank. We're going to get all of this somewhat wrong. So if we checked it, you would see that we're getting a great deal of this wrong in our lifetime. And that's actually normal human behavior, normal human consciousness. That's part one. And so part two, when we question the survivor about her linearity and her memory, we're applying bad science. We are actually applying an assumption that is wrong, which is that our stories are linear. So that is probably, that's super important. And it's something that very few people, I think, are taught or are aware of. So then when stories, and then so now part two, when the stories are not linear, the courts are given only one option, and that option is she's lying or she's not. Now you have a first assumption that's bad, and then a second assumption that's coming out of forensic psychology, which is also bad. And that assumption is if something doesn't add up neatly, that means it's a lie. When in reality, most things don't add up neatly, and it's not because it's a lie. And then part three, which is directly answering Michelle's question of 2 minutes ago, people's stories are not linear because we're asking them about very difficult stories, which happened over and over again. When something happens to us over and over again, at some point, what happened first and what happened after get muddled. And that's just normal human memory. After that, so for example, if you ask someone who's given 200 concerts in 200 countries, they're not going to remember which country, which concert, and when, except for the most important one. Same thing with violence. It's happened so many times, they're not going to remember when and how, right? So I think the first thing prosecutors should be doing is to remember, or when you're supporting your victims, is to remember that is actually normal. It may have nothing to do with trauma. Second explanation, it's related to stress and trauma. So stress and trauma frequently upset our memories, and often if it happened during a very traumatic time, that memory may not have been filed away. We may not even have that memory. So it's not that the person is lying or cannot remember, that memory is just not there. And the third, again, and I'm kind of pushing everyone to think normatively, not pathologically, is that anything that's complex is buried in layers, right? So if you think of it as a pyramid, we have basic information and then more and more refined information. And so it's why people go in for therapy for months and not for one day. As you get deeper and deeper, you get more detail. So as lawyers work more with their clients, or you get more detail. And so it is actually perfectly normal for someone to reveal detail throughout. It could also be that they reveal it at a later point because their memory is not intact. It could also be because of trauma, but frequently it's just how we do it. I do want to say another reason, and this is related to sort of Ross saying, when you work authentically with a client, you give them confidence to say things that they thought no one believed. So some of it, we call it, self-concealment. It's an actual psychological concept. You conceal things when you don't think people will believe you because nobody did. And so they're concealing it. It's not because they're malingerers or liars. Again, bad assumption. Just because you conceal it doesn't make you a liar. You conceal it because you thought no one would believe you. Now you're comfortable, so you're saying it. And finally, this is all part three. And finally, often survivors learn the language way down the line. So working with Brooklyn prosecutors, they have a social service, they have social workers, whom I'm happy to say did their master's first at John Jay, who while working with the client, recognized that she had particular kinds of trauma, which she had not reported. The client gave the social worker permission to take it to the prosecutor. The prosecutor prosecuted. It's not that she didn't remember. It's not that she didn't know it happened. She did not have the vocabulary to name it, nor did she know it was a crime, right? So many different reasons related to so many different things.
Thank you so much, Dr. Aghavan. I think that was a really, really helpful explanation, and also a really great segue into David, and your work at the Brooklyn DA's office. I know that your work, as well as other few offices around the country, have made some major changes to address the criminalization of survivors by working to identify these survivors and then diverting them from the system. I was hoping that you can share a little bit about what that process looks like in your office.
Sure. So it's a few components of how we're looking at it holistically from a full approach. So first of all, like other offices around New York and other parts of the country, we do have a dedicated human trafficking unit that is trained prosecutors in this identification of what a victim might be, what they face and going through, and recognizing the signs of what a typical and also more common atypical trafficking victim may look like, whether it's being as a victim or also potentially being arrested for prosecution-related offenses and also non-prosecution offenses, and how that affect on who they are and what to do with that case is. And part of it is understanding why they engage in the behavior that may lead them to do it, and also how we react and interact with them. We also are the chairs of the Brooklyn Human Trafficking Task Force, which is a federally funded task force to work collaboratively directly with service providers, where everything we do is in a collaborative approach with attorneys, with service providers, to get the best help for the victim as necessary. Every interview we do with the victim, as best as we can, we try to ensure there's a social worker present, whether it's from our office or if they already have a caseworker or a social worker from outside our office, then they're more comfortable with that person. Will happily, whoever helps them the best, feel the most comfortable being in the process. Because we do recognize that whether it's being a defendant or a victim or even a witness, dealing with the criminal justice system is scary. It's nerve-wracking, and nobody really knows what's going on. And having an advocate that's there just for you, for the person, will help them be comfortable, and whether to disclose, whether to report to us or to the police, or go forward with the prosecution, or even just understand how the process means and what it looks like. That's within our own office and how we handle cases, as well as we work with other bureaus very closely within our own office, specifically the Domestic Violence Bureau, where we get referrals from them, or we recognize that oftentimes a case may come in as a domestic violence arrest, where the person discloses because there's obvious signs of violence, what happened to them, and the perpetrator is arrested for assault in a domestic violence situation. But once they come in and they have a social worker or speaking to the intake prosecutor, they're more comfortable, and they disclose that not only was there was just assault for that, their husband, boyfriend, or whomever was also forcing them to engage in sexual exploitation, where it's a trafficking situation on top of just a traditional, and for lack of a better way to say, just a domestic violence assault, where there's more factors there and how to treat them and how to work within that. And we work as well with other units within our office in the trial bureaus, where we're trained to identify potential trafficking, where we're talking about where it's someone who's not arrested for a trafficking offense, but they're arrested for assault or petty larceny or violent crimes, robberies, as direct result of being trafficked, where their exploiter is forcing them to engage in certain activities, or that's all they know and their life had been down that road. And even though that particular crime wasn't with an exploiter forcing them at that second to commit that crime, their life circumstances forced them into that situation. So we're also brought on to consult and help out, to maybe possibly help explain mitigation factors, why someone may have committed the crime that they did, to understand and to explain to other prosecutors who aren't dealing with like victims on a regular basis, to understand why someone may have done what they've done.
Michelle, oh, I'm sorry, did I interrupt? I didn't mean to interrupt, David. I was just going to say, we're so lucky in New York to have prosecutors like David in his office, and the Bronx and Manhattan, prosecutors who are really up to date with modern thinking on these, sensitive to the issue spot on their own, are open to reevaluating cases that look like this, that happened before we had this modern understanding of everything. But that has not been our experience overall. I think that there's a significant divide. We've had great experiences working with prosecutors' offices in New York City, and there are definitely places upstate in New York where we've had, very difficult times. And that's why, we're trying to make education of prosecutors and judges, a priority, because what we're trying to do now is educate at the same time we're advocating. So a lot of our briefs spend a tremendous amount of time explaining the things that Dr. Raghavan explained to us here, having expert reports just on very basic issues, having, amicus briefs on from domestic violence service providers talking about these kind of things. And so, programs that we're putting together, and hopefully these are, across the board to, expose prosecutors who are the first line of defense, educating courts on, modern thinking like this. And, I just have one example that I think might be helpful to elucidate everything. We had a high profile case upstate, and there was a DVSJA hearing. So it was a hearing to get this victim of a survivor of violence sentenced to a lower sentence after being convicted. And the judge, we had a very long hearing. It was multiple days. The client testified over multiple days, very credible, emotional testimony. And at the end of it, the judge denied it and said, there were two basic grounds. The first one was that he said, why didn't she just leave? I heard all this evidence that, the door wasn't locked all the time. She could have just run away. That shows that it's a judge who just doesn't really get it right now. Not somebody who can't be educated in this, but somebody who doesn't understand how dangerous it is for someone to leave, how difficult it is with all of the bonds and coercive control to have children there, to be financially dependent on someone. And his other question was, like we've talked about before, I didn't find her credible because her story changed over time. On the night of the incident, she told the police something totally different than what she's testifying about now. And, the basic idea that you wouldn't understand why someone on the night that something happened wouldn't be able to come to terms with a decade of severe trauma, but could do it when they're ready to, months and months later have a trial, just shows a court that really didn't quite get it yet. So there's a lot of focus on education.
Thank you. And I want to ask Kim, because I know we've brought this up a few times, and the DVSJA, which for those who are watching and who do not know, it's the Domestic Violence Survivors Justice Act that was enacted in New York. And Kim, you were a big part of the creation of this legislation and also getting it passed. I was wondering if you could talk a little bit about how you originally got involved, and also I know that both you and Ross can probably speak to exactly what the legislation does.
Thank you very much. First, I want to say that this panel is just blowing me away with their trauma-informed approach to everything. Where were you guys 30 years ago? Seriously, where were you? So the DDSJA, I actually was involved in drafting the legislation. I was incarcerated, and I was working with a couple of amazing women from the Correctional Association of New York. And we would even talk on the phone, and they would say, how does this sound? How does that sound? And my whole goal was to have legislation or a law on the books where domestic violence survivor would be held credible in court and not go from the prosecution table pressing charges against my abuser to the defense table now fighting for my life, facing 25 to life. So that was my whole end goal. And so we drafted the legislation. And when I came home from prison, I came home in 2008. And in 2009, the spring of 2009, I was right there in Albany for our first lobby day. And every single year we went back to Albany and we marched the halls of the LOB and the Senate side. And we just, we lobbied and we pushed our bill, and we showed the importance of kind of forcing judges and prosecutors to take a look at mitigating circumstances. You don't just wake up one day and say, oh, I think I'm just going to kill this man that I'm deathly afraid of. And, you think that this person is larger than life. And, even after I had shot him and he drove away, I still couldn't believe he was dead because I had PTSD. I was so traumatized.
Oh, it looks like Kim might have been frozen. We'll see if she can join.
You guys are going to report. Oh, okay. Are you okay?
Sorry, you had frozen for a second, but you're back
Oh,
up.
no, that's okay. That's okay. So, you know, we worked on the legislation for 10 years and finally, by the grace of the powers that be, we got it passed. And now it is just, it is so important for the implementation to be done correctly. It is so important, Ross, what you were saying about the education part, you know, and Ryan and you guys, you're hitting it, you're hitting the nail right on the head. It's education, education, education. And I have to say, a lot of it is politics. I also sat in at recent DVSJA hearings where the judge denied the survivor, said she wasn't credible. And it was, I just couldn't help but just cry. It was such a travesty of justice. You know, it was horrible. I said, how can they just re-victimize this woman over and over again? They're not getting it. How do we get them to get it? You know, and it's education. You know, I know the judges, you know, do trainings every year, and I mean, now it's a little different, but I think that it's very important. And can I just touch on one more thing? You guys were talking about getting a survivor to talk about what had happened to them and getting them to open up. Can I say that because it's hard to do it in person now because of the pandemic and everything is different, nothing is normal or as it was a year ago, right? Actually, I think social media, like, well, actually not social media, but Zoom calls would help, because I think I would feel safer in my own home talking about these things like this than sitting looking in someone's eyes face to face and feeling their expression and their emotions. You know, I don't think that everything that has happened has hindered communication. I think it's actually helped it, because most people aren't comfortable now in the same space as others, you know, and especially a battered woman, a woman who has just been abused and broken. And, you know, she needs that. She needs that safe space. And to be, I think just for me, I would be comfortable, you know, more comfortable, you know, just coming from that perspective. I don't have to be with you. I don't have to be in the same room with you. I don't have to be intimidated by you, whether you're intimidating or not, you know. But the DVSJ, getting back to the DVSJA, I think that it will force judges and prosecutors to take a look at mitigating circumstances and why these things are happening.
And if I just want to follow up on that, because to that point of the education and making the community aware, that is a big part of what we're doing through our office and also through the task force, is giving the trainings, giving presentations within our own office, within New York City, as well as other parts of New York State and also around the country. And like to Kim's point, having the virtual world, you can reach a lot more people, and really just explaining the best practices and from a prosecution standpoint of dealing with victims and how to handle it. Because we do believe that if you're understanding from that standpoint from the beginning, and obviously we're working really hard to right the wrongs of what's happened in the past, but hopefully going forward, we won't make those same mistakes and we can go forward on a better avenue for investigation, prosecution, and dealing with people. And to that end, that's a big part of what the grant is and how our office operates, not just in the trafficking unit, but within the special victims unit, the domestic violence bureau. It's very focused on victim centered and doing everything for the victim in the best way possible, and recognizing that it is all about helping the victim grow. And oftentimes, sometimes it means a case may not proceed because it's not in the best interest of the victim. That's where we take off that prosecutor hat and be like, we understand it's not good for the victim. We're not going to force, we're not going to compel someone to testify if it's to the detriment of a person, because what do we gain out of it? And just the one point I did want to mention about our office is proactive, most importantly, in a sense of criminalization, we no longer are requiring the court to mandate in a prosecution arrest, the court to mandate someone to go to services and meet with a counselor and force them under the threat of, if they don't comply, then there's going to be sanctions, whether it's going to be a conviction or a warrant if they don't show up. That's used to be how it is, and the DA is very concerned of having courts forcing people to do things, because ultimately that contributes further to their victimization. So what we started doing in Brooklyn on prosecution arrest is, well, first we're trying to work very hard to make sure that the arrests don't happen to begin with, but when arrests do come in for prosecution, we're immediately diverting, without going through the courts, connecting survivors, connecting the people arrested with the programs, with the service providers to do this program mandate without having a mandate from the court. And as soon as we make that connection to the service provider, we're dismissing the case even before their first court appearance, and no longer requiring the court to monitor their compliance, because oftentimes it doesn't help right away. It takes a couple times, and having them have to come back to court if we recognize potentially that someone might be a victim, that's not in their best interest. So we're kind of doing it before the court system gets involved to take that, even that one part of going to court, even though it's a diversion court, even having to not have to deal with that court system, that can help go towards helping the victims as well. So I just wanted to make sure that people were aware of how the office is treating these cases.
No, thank you, David. And I want to follow up quickly with Ross, just to go through just some of the specific things about the DVSJ, like exactly how prosecutors and defense attorneys can use them. And then I'm going to ask a quick follow-up to Ryan, but thank you.
Yeah, so great to hear David, by the way, talk about that, his office. And I can say that, Brooklyn has been really leading the charge, the DA's office, along with a couple others in New York. So about the DVSJ, very briefly, it's such an important and such a groundbreaking law, and Kim did, something really, really important by getting this passed. So it provides a mechanism in New York State, actually a requirement for courts to take into account and to consider, holistically, a survivor's life history and experiences in fashioning a sentence. And it provides a mechanism at two different stages of a case to do that. The first one is before a sentencing. So after a trial, when someone has been convicted, they can have a hearing where they can put forward pieces of evidence to show that they should be sentenced to receive a lower sentence under a different sentencing scheme that's part of this DVSJA, that's part of the act. It also provides the opportunity for people who are serving, survivors who are serving a sentence and never had the opportunity to get these facts out, to come back before the court and have a resentencing hearing where they give, all of this background that's so important that should have been considered in connection with their initial sentencing. And, for any lawyers in the room or people who are interested, there are actually 3 requirements, and they're very quick. So at the time of the criminal offense, the survivor or the defendant has to show that they were the victim of substantial physical, sexual, or psychological abuse inflicted by an intimate partner. Number 2, they have to show that that abuse was a significant contributing factor to the crime. And number 3, they have to show that an ordinary sentence, or the sentence they received before, was or would be unduly harsh, taking into account all of this. And for those of us who have practiced in federal court a lot, federal courts take this into account all the time. But in state court, as a function of the way they do pleas and other things, this information often does not get out. There are a lot of times, because it gets lost in the shuffle, a lawyer, an advocate who's supposed to get this out for whatever reason doesn't get it out at trial or in plea negotiations. The judge never heard it because it never came up at a sentencing hearing where there was a promised sentence. So it's so powerful. It gives the opportunity to put all these facts in front of a court and have, require the court to consider the full circumstances of someone's life before issuing a sentence. And Michelle, either now or later, I'm happy to share a story that Dr. Raghavan and I have worked on a case, and it was a successful case, and it just shows, the power and the breadth of the law if you run into the right prosecutors and the right judges.
No, absolutely. I think we're going to be able to, I have a good follow-up question for later for you and Dr. Raghavan. But I want to ask Ryan, you have worked closely with, actually I know David, but prosecutors in Brooklyn, the importance of this collaboration between both prosecutors and defense attorneys seems to be really essential, right? You have to have this interdisciplinary approach from different mediums of psychological understanding, but both the prosecutor and the defense attorney do need to work together in order for things like the DVSJA, but also just the general proceedings that are taking place in Brooklyn to work. So I want to ask you, what has your experience been like, and what are some ways that you think either the office can improve? And also then, David, I would love to hear from you on what your experiences and work taking this really collaborative approach, right, to prioritizing survivors.
Yeah, so It's an interesting dance being a defense attorney and having a client who is simultaneously a defendant and also a victim. And it's a tricky space to navigate. Sometimes my clients want to cooperate with prosecution, and sometimes they don't. And it is very helpful to have a counterpoint in in this case, the DA's office, that can be like a person that I go to who is knowledgeable in what we're talking about, subject matter. And I think that, for this victim survivor sort of mitigation conversation to move forward, it is really important for like all relevant parties' offices to have a point person. So for the prosecutor's office, that would be like a human trafficking unit, or at least an individual marked, and in the public defender offices as well. And I think also in the courts as well, to have a point person to be able to come together and have conversations around victim survivors. And then we can each internally in our organizations disseminate that information. And I think that's an essential like starting place for all of us. I know there's a lot of prosecutors and defense attorneys listening. So I do encourage like all as offices to develop that person. And it, like we've all been saying, like there's common themes here. Training is really important. I have worked a lot with Dave. I mean, he is my point person for an individual who has experienced trafficking in Brooklyn and is being prosecuted by Brooklyn. And I think, what he and I, and, he can comment on this as well. We've really tried to develop open communication, that we're both open to talk to each other and we listen to each other. And we try to find common ground. A lot of times we agree to disagree. I think that's like our new hashtag. And that's okay. That's okay. But it is important to have that person in your adversary's office. I mean, a lot of litigators, if we were doing this in person, would probably start chuckling at this part of the conversation, because this is an adversarial system and we don't typically come together and sit and listen to what each other have to say. But I think when we're dealing with victim survivors, that's an important element of advocating for them and making sure that their desires are being heard and their experience is being heard.
Thank you. And David, do you want to follow up on what your experience has been like? I know that you guys have made a concerted effort to work on that collaboration.
Oh, and I agree with what Ryan said. It's true. We're not always going to agree on cases, and obviously priorities of like public safety. Sometimes we have to balance that with what from the defense side, what they're looking at. But we really try as best as we can to have the common ground and have that. And what I think more important is that open line of communication, where I know if I'm having an issue with something or something that needs to be addressed, I can call Ryan and off the record let her know, look into something, or this is not right, or this isn't being handled right, or this was done well and this is what we could offer. I know recently I reached out to Ryan about a possible case that in our office I saw where someone was arrested, nothing to do with trafficking. It was a routine misdemeanor arrest. And I reached out to Ryan saying, hey, this is person is being represented by your office. You should take a look. I am aware of this person that has history from going back 5 years ago, where there is trafficking history. This is something you should take a look at. And at the same time, I reached out to the prosecutor on that case, giving them the backstory and working and recognizing that not all cases on the surface are what it is. And I think that's the most important thing, that we're never always going to agree. It's just not, that's just the system that we're designed in. There's always going to be differences, but recognizing that the ultimate goal is to help further justice, but also helping victims, which goes hand in hand. And if justice is not being done, then what are we doing? Then we're not doing the right thing. So I think having that communication and understanding different standpoints, because many times there's needs that from a defense attorney standpoint, they recognize things that we're not as prosecutors attuned to. Sometimes like the collateral issues, whether it's this person may also need immigration help or job help or other legal services that's not strictly fighting criminal charges, that we're not as prosecutors, that's not necessarily what we're always recognizing. Ryan is more in tune to that and can see the other services that this person may need or other issues that are impacting this case. And that's something I think both sides looking at it from all avenues is what really makes a difference, I think. And just to that point, and I know I meant talking about even prosecution cases where ultimately we all know oftentimes those will get dismissed. From a prosecutor standpoint, is okay, if we're going to dismiss the case before it gets to arraignment and we're done and there's no criminal case, why do we need a defense attorney? What's the point of even having someone in that system if we recognize that the case will go away right away? There's no need for that. And that's where Ryan is pointing out those services, like I mentioned, of the other legal ramifications or legal issues that a person may face, which has led them to be in that situation to begin with. That if that's where those lawyers can help them from that regard, I think it is important. And I think having that approach of keeping those communications open really make a difference.
Thank you both so much for sharing that. And following along this theme, right, of keeping this interdisciplinary approach, I want to ask Dr. Raghavan, your work on trauma coerced attachment has been essential for a lot of judges, specifically in New York, but around the country, and understanding the psychology of survivors who have committed these crimes as a means for either self-defense or survival. So I was wondering, how can researchers and clinicians work with the courts to ensure that this information is both accessible and used at each stage of the criminal justice process?
So there's no simple answer to this, and it's because of at each stage. If it were, how can the courts use, then it's a simple answer. Bring a competent expert. And by competent, someone who works in trauma, not a general expert, because general forensic experts rarely work in trauma. So every stage of the way, so one example, which I've a little bit brought up was in the case with David, and there've been cases like that I've done with prosecutors in the Bronx and Manhattan. If you have someone right sort of at the beginning of the process who's a social worker who can start to identify big clusters of issues, then that will alert the prosecutor around the big clusters of issues. So was there coercive control? What kind? What was the proximity of the abuse to the event? Those sorts of things. So I think that can be very helpful for prosecutors to start thinking about the case in the correct way. It might enter as DV, but it's really trafficking, or it might enter as DV, but it's really sexual assault. I also think that having social worker or counseling psychologist type person with the police, I know it's a dream. Taking the domestic violence and sex trafficking reports will be immensely helpful, because how you charge or how you think about the case starts with the first report or the first encounter with the police. And we have domestic violence police who are excellent and well trained, but if the person taking the report isn't DV police, or it's late at night and he or she is tired or not sensitive, the report's not, that's when all of these problems start. Well, why didn't you say it, when you call the police? Because he didn't ask. Well, but it's not his fault that he didn't ask. He wasn't, the police officer wasn't trained specifically to understand how subtle, manipulative domestic violence is. He's trained to ask, did he hit you, did he not? And that's it, right? So I think to really embed the right personnel at every level, which would be, counseling psychologist, social worker, caseworker type at every level, will help it be framed when prosecutors get the case, which will then, then you can make the decision how properly to try it or not.
Thank you, Dr. Raghavan. And my next question is for Ross, but also Ryan, I'm hoping that you would jump in and share your experience. But, Ross, you have been able to employ Dr. Raghavan's work and other expert testimony to help explain why survivors who have been charged with these violent felonies should have their histories of abuse and trafficking used as these mitigating factors in a case. Can you share a little bit more about the challenges that you've faced trying to convince either prosecutors or judges to really take into account a person's history before?
Yeah, I mean, look, hearing David here and seeing, how many people are in the audience here, I hope this problem is heading in the right direction, because a lot of it, like we talked about before, is just not being in touch with how to handle these cases, with how to address survivors, with how to analyze the cases. And we're seeing in New York City at least a lot of receptiveness to new ways of thinking. And with the understanding that in New York State, there's a lot of territory where I think this hasn't diffused yet, and certainly throughout the country. But in New York City, we're running into a lot of receptiveness. I don't know if it's a younger generation that has sort of grown up more progressive and is understanding these things, and has an easier time, adopting this new information and employing it, or it's just social cues that are making this more something that everybody wants to get on the bandwagon and understand and be more enlightened. But we're in a positive direction in a lot of our cases, working with Dr. Raghavan and others.
Now, I want to jump in very quickly and say, I think part of it is also many of the young lawyers I've worked with, and by young, I mean well under 30, so they're coming as externs. They took domestic violence classes, and 1 or 2 law schools mandated. So the answer to the previous question of in Michelle is education. And so a lot of the lawyers I've encountered, were exposed not necessarily to coercive control or trauma, of course, attachment specifically, but the idea that trauma puts you in a difficult place, and that leads to ways in which you don't tell the story necessarily clearly. And so then your job as a lawyer is to figure out what you need to do to get that story. They already come with that idea. And I think, one of the ways is to have law schools really do much more of it.
I'll just add in here that I do agree. I think that we are heading in the right direction, but I think that what I see is the gap between prosecutors who are familiar with Dr. Raghavan's writing and are receptive to it, and then them actually having to employ that with a victim defendant who's charged with a felony or even a violent felony. And that gap is where I find myself spending a lot of my time. And it can be very frustrating, because it's one thing to speak and say that you're receptive to these, progressive policies. It's another thing to actually implement them. And I see a lot of struggle there.
And following up from what Ryan said, even prosecutors, judges, defense attorneys who have an understanding of the basic principles, where the advocacy is here is in the nexus between what they experienced and the incident that brought them into the system. So in my case, many of them are, victim defendants. I think Ryan's as well. In other cases, they're victim witnesses. And understanding, not just what's going on in the background, but how what they experienced impacted what they did, how they'll testify, how they communicate, things like that.
Thank you. And following up off of that, Kim, I know you've been active in your advocacy work with a lot of survivors. So I'm wondering what are some things that you also think need to change between like prosecutors and judges in order to better understand these histories?
Well, I think like everyone is saying, I think we're headed in the right direction. I really do. We're not quite there yet. I think that taking a more humanistic approach to everything, it used to be somebody died, somebody has to pay. And that and men and women were sentenced under the same sentencing guidelines, no one ever mitigating circumstances or factors. So I think we're headed in the right direction as far as having the courts take a look at people as people. I'm not docket number 3764. I'm a human being. And I used to be, like I said, on that side of the courtroom. Now I'm on this side of the courtroom. And I think coming together, it's so difficult. It's so difficult to change people's perspectives and attitudes, even though there's a law that says you have to look at this, There's bias, there's racism, there's a lot of different circumstances in the courtroom that people don't talk about, don't touch on. The judge looking at you, the DA looking at you. I had a female judge, a female DA, and I thought that they would understand, but they had no understanding, no compassion, no empathy. And I'm not just saying because they're a woman, but I'm saying that what woman doesn't understand being attacked? And this was my mentality. There are some that don't understand the fear of sleeping next to the person that you're afraid of. Nobody understands that. So I think that just this push that we have going to see people as people and to see victims as victims, it doesn't make you a prosecutor to acknowledge that a woman is a victim survivor and help that woman. Because look what you're doing to her life. Look what's already been done. And that's her victimization. But look at how you can lift her and you can actually save a life. And saving that life and seeing this woman as a human being and not just a criminal. I'm a survivor. But first and foremost, unfortunately, now I'm seen as a felon. When I go for a job, I'm seen as a felon first, not a survivor, not an advocate, right? So I think that stigma of somebody died, somebody has to pay. Something happened, somebody has to pay. It's the world isn't cut and dry like that. Situations aren't cut and dry like that. I think that, like I said, this push, more progressive, more human push to see people as people and not, like I said, let's not just fill up the jails because we have to fill up the numbers. Let's not just lock them up and throw away the key because that's all you know to do, because it takes a little bit more work and a little bit more digging to do the right thing. And I do believe that eventually are still there, just not quite there yet. But it sounds like everyone on this panel, well, you guys are powerhouses and you do a great push. This is a great thing. It fills my heart and my soul to see the DVSJA being implemented, seeing it help people, but also seeing that we have a lot of work to do with educating judges and prosecutors in this area.
Absolutely. Thank you. And following up off of the point about the importance of you now have this title on you as a felon on your record. I know that both Brian and David, you have been working in Brooklyn with the vacation of a lot of sentences in New York City. So I was wondering if you could share a little bit about what survivors can do who are either currently incarcerated or who have had past convictions, what they can do to vacate their sentences and what you guys have been working on.
Sure. So just from the stamp of the mechanism of how to do it, there's several options for someone to file a motion for whether for vacature or to look at a second look. And so the one that we deal with the most in human trafficking unit is the 440 vacatures. And currently, as the law is written, it's prostitution and loitering for purposes of prostitution convictions that were obtained as a result of being forced into trafficking. So we get those a lot now, those 440 motions to vacate old convictions with it. And more often than not, they're misdemeanor convictions and then related offenses as well, whether it's drug offenses or trespass or petty larceny, that were all at the same time and as a result of being trafficked. So we get those 440 motions. I will say that in the last couple of years, a little bit more than that, we've vacated in the hundreds of convictions, of old convictions, where we've looked at those where people have filed 440 motions and we have vacated hundreds, possibly even more of old convictions because we recognize that it was as a result of being trafficked. Our office, obviously we have the DVSJA, which people have been speaking about, which is also an official motion filed to the court. We have as well the conviction review unit, which in our office, which historically is righting a wrongdoing. And it doesn't necessarily have to be where there was wrongdoing, where the conviction was obtained in a wrongdoing, whether by misconduct by a police or a prosecutor, but it's also knowing what we know now about the wrongs that forced a person to commit what they did. It's also potentially righting a wrong of what someone was forced to undergo. So It doesn't necessarily have to be a specific allegation of misconduct, but there is a mechanism of just righting a wrong because we recognize that a wrong was done and we have that mechanism. So I think just from the intake of our office, and that's a determination that I think someone like Ross or Ryan, their position, they're much more understanding of the facts of why they may choose to file or go one route versus the other. But those are the basic ways that our office can get involved from the prosecution standpoint, is a motion for 440, the DVSJ, or submitting a request for the conviction review unit to look at a conviction, a previous conviction.
Yeah, so like Dave said, the 440 motion that allows for prostitution-related convictions to be vacated was created in 2010 in New York. And we were the first state to enact legislation that provided that type of relief. But it's narrowly tailored, like Dave and I just said, it's limited to prostitution-related convictions that were a result of an individual being trafficked. The project that I'm part of, we file 440 motions. We've actually filed 177, resulting in 1,859 convictions being vacated thus far. But it's important to point out that of those individuals, 30% of them had convictions that were not prostitution related, but were in fact due to trafficking, and they were not eligible for that relief because the law is not written to provide that. So there actually is a legislation pending in New York to expand the language in 440 and to increase the class of convictions that an individual would be able to have vacated. And I think it's important that that legislation be passed. But we work with attorneys in New York State and also across the country, because a lot of states at this point now have adopted similar laws. And I just wanted to put myself out as a resource. If anybody wanted to find a way to get in touch with an attorney that could help with that, I'm more than willing to help connect people.
Thank you, Ryan. And we'll have your information on our website. So if anybody wants to follow up with that. And lastly, before I ask my final question to each of the panelists, I know, Ross, you had a really powerful story about a recent case that you and both Dr. Raghavan had worked on using the DVSJ. If you'd like to share it with our audience.
Yeah, I'm happy to talk about it. I like sharing it because I think it, it gave me a lot of hope that we're heading in the right direction and that we now have a sort of a powerful weapon, and that we have prosecutors and judges that are all going to work collaboratively and on the same page. So I'll tell the story pretty quickly. So this is a client who came to us. She was serving 10 years for a robbery conviction. She took a plea. In 2011, she was in her early 20s. She met a man up in Rome, New York, upstate New York, Rome. And she thought it was going to be a serious, loving relationship. She considered him a boyfriend. It got very serious very quickly. Within a few months, he convinced her to move down to the Bronx with him. And, as we see in so many cases, the abuse began almost immediately. She had a very supportive family, including a young daughter up in Rome, New York. He cut off all of her communications with her family. He started hitting and punching and choking and raping her on a daily basis. He'd never leave her alone, took away her cell phone, keep her locked up. And once he had isolated her and broken her down, he started advertising her on Backpage.com for sex. And one more thing I should mention, he forced her, and we see this in the trafficking cases so often, to get a tattoo of his name, a huge tattoo across her throat. And like, what a crazy reminder every day. She's in prison, having to see that on herself. So he'd force her to have sex with multiple men every day. He'd keep the money. When she refused, he would, beat her even worse than he was without that. Ultimately, one of the forced sexual encounters turned violent. The John started taking drugs. She called her trafficker outside, said, "I'm not comfortable." He came in with another man and beat the John to death with a baseball bat. And it blows your mind, but originally she was treated like a defendant. She was not treated at all like a victim. And somehow the ball was dropped, and none of this background to how this man was robbed because after they killed him, they all grabbed the cash and whatever, marijuana he had around and run out. She was treated like a defendant rather than the victim. It never got before the court. It never got before the prosecutor's office. We were able to work with her and go to the Bronx DA's office, where we ran into an ADA who was just so literate in these issues and ideas. And she became the greatest advocate for this client we had. We were struggling to get hearings with the judge to get this on the docket. She wrote powerful messages and briefs. And, just talking about somebody getting it, I just have one quote from her brief that I think really illustrates everything that we're talking about: education and getting, everybody on board the same way. She talked about traumatic control and bonding and everything. And she said, her conclusion to the whole brief was, it can't be overlooked that someone was killed, an actual person was killed during the robbery. But the defendant, our client, exhibited no more agency in that regard than the baseball bat that was used by the trafficker to kill the decedent. She was the trafficker's tool and not a wholly independent actor at the time of this crime. And the prosecutor supported her immediate release. The court took it on without a hearing because both sides had agreed to get these facts out in front of the court for the first time, that she should be released immediately. And the lawyers who worked on the case went and met her when she was released and took her out to her first lunch outside in 10 years. And this is the power not only of the DVSJA having a new statute that can give second looks to cases, but having people involved in the system that all want to do the right thing, that all want to, fix things that may not have been done right the first time. And it was very encouraging to me, and I hope it's encouraging to everybody.
Thank you for sharing that. I think it's an incredibly powerful story. And I'm being mindful of the time. And I know I'm going to ask one last question of all of our panelists tonight. So we obviously have prosecutors watching from all over the country who are hoping to leave today's panel with something that's actionable that they can do going forward. So can each of you name one action prosecutors can do, or a priority that they should have when looking to address the criminalization of survivorship? And I'd like to start with Kim.
Hi, thank you. Wow, thank you for that powerful story. Also, it's like bringing tears to my eyes to hear this come to fruition, and to hear that we have saved the life of a survivor through the DVSJA. I think going forward, assisting survivors to feel powerful again, help them regain their power, help them regain themselves. I want to tell you quickly, at Easter, when you take an egg and you tap each end and you blow out the inside and you have this beautiful shell and you decorate it, it's something we used to do in grade school. And I used to see myself as that decorative shell, but empty. And I think if you approach a woman or any survivor, man, woman, transgender, it doesn't matter. If you approach any survivor with the kindness and the gentleness that you would show that delicate, decorated shell, because I was empty and I needed a way to regain myself and my own power as a human being. And I think that if that trauma-informed approach and that gentle guidance, and every time I tell a story, every time I talk about what happened between him and I grow and I heal a little bit more. So just knowing the platform that someone needs to open up or to share or to heal just a tiny bit more every day, that is what you need to think of when dealing with someone who has been through this type of trauma, because it's like no other.
Thank you, Kim. And I definitely want to follow up with what you're saying by also mentioning the importance, I think, right, of having survivors at the table when all of these decisions are being made. I think that the DVSJ and the success of that so far has been completely because survivors were the ones who were there, sitting there, writing that legislation and advocating for it. So I want to thank you for the work that you've done, but also to emphasize that for everyone who's listening and everyone on this panel. So thank you. David, would you like to go next?
Hard to follow that, but I mean, it's been said already a few times, and I just want to echo that. And I think it's really important not to have preconceived ideas of what we're looking at. Just because someone may have committed a crime doesn't mean that the only thing to happen is punishment. There's mitigating factors, recognizing why someone could bring themselves to commit a crime or what forces someone to commit crimes. And I think just evaluating each case as it comes in. I know that's a big push from the district attorney and our office. We do try as best as we can on every case to really take it out of everything and look at it as this individual case by itself. What are the factors surrounding it? What led the person to do it? What are potential mitigating factors? And I think looking at it from that lens of like just this case by itself and not we're a prosecutor and we want to full steam of the law, because full steam of the law might be no jail, might be no program, might be dismissal. Really just evaluating each case and what led a person to do what they did, I think really goes a long way, and also shows that sensitivity of like, listen, there might be times where, depends on the facts and circumstances, we might be advocating for jail, we might be pushing for punishment, but that's only done once we evaluate all the options and we determine that that's the only recourse, that's the best way to proceed, but doesn't mean every case has to have a punishment, or just evaluate each case by itself and treat victims and treat people like people. So oftentimes people tend to forget that, and it's a name on a file, it's a name on a case, and if they're overworked, overburdened, then there's a lot of cases coming through. You look at the facts, you move on, and you're not really taking a second look of behind all those files are real people on both sides of the aisle, and the ramifications are great on either side. So really just giving that attention that each case deserves. And I think all we can hope for is getting to a just result, however that might be.
Ryan?
I would say to the prosecutors listening that I want you to know that victims are being arrested, and I guarantee you that victims are in your current caseload. It is so important that you all know that, and I would love to see a day when all ADAs are trained on identifying survivors and are taught best practices for engaging with survivors.
Ross?
Yeah, I mean, I agree with what everyone has said so far, but I think that one easy trick is to sort of, for us all to realize that in many of these crimes we're looking at, in many of these offenses, many of these situations, there doesn't have to be just one victim, and people are victimized in different ways. I think it's very easy for a prosecutor, for an investigator, for law enforcement to use almost like a box checking system and saying, you know, this guy is in the morgue and he's the victim here, and then this other person who killed him is the perpetrator, and it's very easy and neat. And a lot of these situations are not like that. There may be, you know, the perpetrator may be a victim as well. You know, the person who is the victim may have been a perpetrator, and it's not clean and easy in these kind of situations. And using a box checking, fill in the blank for where they all fall in a situation just doesn't work in cases like this.
Thank you. And lastly, Dr. Raghavan?
For the prosecutors listening, I would say do two things. And one is, if these cases come to you, if these women get arrested, one of the things that all of us have heard is, why didn't she leave, right? Well, women do leave. They leave all the time. Those are the cases you're not getting. And if they didn't leave, it's because they couldn't leave. They tried to leave. He stalked them. They had nowhere to go. They had no resources. So it's doubly punitive to say, well, she didn't leave, therefore she's not credible. It's actually a failure of logic. And if you look at it statistically as a science, most women leave. It's who you encounter are the women who couldn't leave. And related to that is then, how do you know she couldn't leave? And I would say to all the prosecutors, measure power. I call it coercive control, and that's what I study, but you can call it whatever makes sense in your state. And measure coercive control, and don't just measure physical abuse, because what happens in all of our lives and in women's lives is, you know, the abuse is bracketed by physical and sexual violence. But in between that, like an insidious sort of poisonous river that's running from act to act, are acts of manipulation and blackmail and blame and things that trap the women. And so the closer you get to figuring out the power, the more this, what feels like an irrational act will become very irrational. Why she stayed will become clear. Why she had to strike will become clear. Why she complied when asked to rob someone will become clear. And I think for you to move then from, to seeing her as a victim, not as a point of morality or not as a point of humanity. I mean, those things are good, but purely from a point of science will become very clear. So, use science and it'll be really clear that morality is on the side of science. Measure power carefully.
Thank you all so much again for joining this panel. It's been a pleasure to have all of your voices on this very, very important topic. And thank you to our audience for tuning in. To learn more about this series and the other panels that we've had, I put a link to our website in the chat box, or you can just check out prosecution.org to look at the past panels in this series and also to stay up to date on the upcoming panels. Again, thank you. And I hope you all have a great night.